For an international firm or a foreign manufacturer, the Indian legal jurisdiction is often perceived as a massive black hole for commercial recovery. Imagine this. You execute a multi-million-dollar export contract with a large Indian corporate entity. You ship the goods. The Indian importer clears them at the customs, consumes the raw material, but deliberately defaults the final payments. Your local counsel in India advises you to file a standard civil suit for recovery. Or if you have an arbitration clause, they advise you to fight the arbitration in Singapore or London and then bring the arbitral award to India for enforcement. The brutal reality, standard litigation or even enforcing a foreign award in India can take easily anywhere from 7 to 10 years. The Indian defaulter will use every loophole, filing frivolous appeals, raising public policy objections, and delaying the execution. By the time the Indian Civil Code finally passes an executable decree, the defaulting entity would have siphoned off the funds and your client is left with nothing but a worthless piece of paper and massive legal bills. Hi, I am Advocate Ashish Rishi, Managing Partner at Northwest Legal Consultants, India. Today, I am going to decode the exact multi-layered statutory blueprint of our firm uses to completely bypass civil court delays, paralyze the Indian defaulters, and choke them into rapid settlements. Elite corporate execution does not rely on asking a civil judge for money. It relies on choking the defaulter's ability to do business globally. We deploy a two-pronged statutory approach. The first, regulatory weaponization. When an Indian importer defaults on an international trade payment, they are not just breaching a private commercial contract, they are actively violating the Foreign Exchange Management Act of India, 1999. We call it FEMA, FEMA. And the strict master directions of Reserve Bank of India, RBI, regarding the import of goods and services. Instead of standing in slow civil court, we escalate a highly technical regulatory grievance directly to the RBI and the import's authorized dealer bank. Under Indian law, an importer must remit payment of imported goods within a specified time frame, usually 6 months from the date of shipment. If they fail, our objective is to legally force them, the AD bank, to flag the defaulting entity on IDPMS, Import Data Processing and Monitoring System portal. The moment an Indian corporate is red flagged on the IDPMS portal, it's a death sentence for their international trade. Their global trading lines are frozen. They cannot import new raw materials. They cannot remit any funds abroad. And Enforcement Directorate (ED) can initiate investigations for foreign exchange violations. This regulatory chokehold forces even the most stubborn corporate defaulters to the settlement table within just weeks. Because you are not attacking their bank balance, you are attacking their survival. Simultaneously, we prepare the second most aggressive weapon. If the defaulted commercial debt is above 10 million Indian rupees, roughly 120,000 US dollars, we completely ignore the civil courts and strike via the Insolvency and Bankruptcy Code of Indian Constitution, IBC 2016. We do not file a suit for recovery. We serve a Section 8 statutory demand notice. If the payment is not remitted within 10 days, we file a petition before the National Company Law Tribunal of India to drag the entire company into corporate insolvency. The threat of the NCLT admitting the petition is catastrophic for the Indian promoters. The moment insolvency process begins, the entire board of directors is suspended and the management of the company is handed over to the court-appointed resolution professional, so-called RP. Furthermore, if our legal investigation reveals that Indian directors siphoned off the funds to avoid paying your client, or that time we invoke Section 66 of IBC, fraudulent trading. This allows the tribunal to pierce the corporate veil and attach the personal assets, private bank accounts and properties of the directors to recover that client's dues. The fear of losing their company and their personal wealth forces immediate prioritized out-of-court clearance of our foreign clients' invoices. At Northwest Legal Consultants, we operate exclusively on expedited statutory framework. We act as the aggressive execution ground force for our international partner firms, arbitration practices, and foreign manufacturing entities navigating the complex Indian jurisdiction. We understand that for an international firm, client accountability and speed of execution are paramount. If your dispute resolution desk is currently struggling with stalled cross-border recoveries, dealing with bad debts from Indian importers, or facing resistance in enforcing foreign arbitral awards in India, do not let judicial delays dilute your client's claims. Reach out to our international litigation desk directly at legal@nwlc.in or visit our official portal www.nwlc.in. We assess the jurisdiction risk, we execute concurrent regulatory and insolvency pressure, and we secure the funds. So this was Advocate Ashish Rishi. Thank you so much for watching, and I'm looking forward to connecting with your firm ASAP. Have a blessed life. May God bless all. Thank you so much.